Bless you. Good morning, everyone. We are live with the civil docket in Barron Circuit Court. I am continuing to allow folks in. It usually is kind of a rolling process at the very beginning here. All right. Okay. My first question is going to be to inquire of anybody if he or she is on duty in another court. They're waiting for you, whatever the case may be, because I don't want to have you sticking around if you got another judge somewhere that's about to get mad at you. So we'll try to get you in and out if that's okay. If there is anybody that has that issue, let me know. My second thing will be that if there is anybody, I don't know what I did with my docket. Okay. There we go. If there's anybody that's on in the matter of 17 CI 179, that's the Spencer Benedict Farms case. It's my understanding there was an agreed order tendered. I believe that took care of what's on our docket for today, but if I'm wrong, let me know. If I'm right, I just wanted to bring that up so that if you were an attorney here on that case, you didn't have to wait around. Mr. Jones, I know you're on that one. I don't know if you have another one or not. Oh, I can't hear you.
I'm on Billy Sanderson.
No, I was talking to Mr. Hank Jones here.
Oh,
Yes, sir.
okay, I'm
Your
sorry.
Honor, I apologize. I was on mute. I
Yeah,
came
that's
on
right.
out of an abundance of caution. There is an agreed order noting the settlement and then the change of the one of the parties' names due to death. So I think everything's been taken care of. And I apologize for my informal attire this morning. I'm at home recuperating from some surgery, so I just thought I'd say that. I apologize for that, Your Honor.
Hey, look, what am I going to say? Look at me. All right. You're all right. You're in good shape. Yeah, I just wanted to raise that issue so that you would know that you didn't need to stick around. Okay.
Thank you, Your Honor. Have a good day.
You too. Good luck to you.
Thank you.
I mean, I don't know what to tell you. He needs to call you and then you let me know and I'll get him on the phone. All right. If there is nothing else that anyone needs to call out of order, I'll just run through these in the order that they're appearing on my docket. The first case that pops up now that I have gotten past that one is 17 CI 591. That's Allen and Davis versus Gingrich.
Your Honor, that's my motion to Matt Garman representing the plaintiffs in the case. It's my motion for substitution of parties and to revive the action. One of the defendants passed away roughly a year ago, and the statute allows us to 1 year to file an application to substitute, and we've done so.
Judge Zachary Taylor for the defendant Abe Gingrich. There is an objection to both motions. I have filed just this morning a written objection to both motions. Essentially, the plaintiff failed to name the successor or representative of the decedent, Danny Gingrich, and that failure is essentially requires dismissal under the case law and the statute.
Well, I was curious because I've never had the issue come up where there wasn't either a successor in the form of state or where that wasn't identified in the motion. So I haven't done any research on that, of course, and I haven't seen your reply or your response. I guess I should call it, Mr. Taylor. you know, if it was filed this morning, I'll just need to take a look at it. I haven't looked at it yet. So, you know, I can give the movement the opportunity to file a reply to that if you, I'm sure you haven't seen it either. So,
I have not.
yeah, Mr. Garmin, I can give you an opportunity to file a reply to that if you want me to give you 10 days or something like that.
That'd be fine, Judge.
All right.
And Your Honor,
Yes.
Jason Osbach here. I actually represent an intervening plaintiff in this case. I'm only on here to indicate that we don't have an objection to the motion.
Okay. So I guess I would give you the same 10 days to file something if you wanted to, or but if I won't hold it against you if you don't file anything. So
I'll review the pleading and then respond accordingly.
Right. All right. Very good. And so, Mr. Taylor, your objection is noted for the record. And once again, I haven't seen it, but I will look at it, and I'll give Mr. Garmin 10 days from today's date, which is going to put us over into something along the lines of we'll just call it April 21st. I'll give him till April 20, close of business on April 21st to file a reply, and then I'll take it under advisement and go from there.
Your Honor,
Hold on, Tim. I haven't gotten to you yet.
thank you.
I do see you though.
Thank
I
you.
was told you weren't going to be here, but I'm glad I was wrong. All
I
right.
didn't know you ever were wrong.
Well, you've heard of leap year, haven't you? You know, every now and again, February is wrong about how many days it's got. Mr. Garmin, I'll give you till close of business on the 21st, and then we'll go from there. Okay.
Thank you, Your Honor. That's all I have.
All
If I
right.
may be excused.
Good deal. Yes, sir. Thank you.
Thank you.
All right. Yeah. Everybody that's associated with that case is free to go.
What, did I get to say anything?
I haven't gotten to you yet.
Okay, I got you. Sorry.
I'm coming. I'm working through these in a systematic fashion.
In order of importance.
Yeah, in order of importance. 19 CI 711 Sanderson versus Graves and Scotty's Contracting. That
Hi,
is,
Judge.
yeah, that is a motion for partial summary judgment. We had that set for a hearing once before, and then we passed that until today. I think maybe there's been a response filed. I don't know that anybody has anything else they want to file in that case.
No,
Unless you want to
Judge,
file a
and-
reply.
I don't think I need to. So it's good to be submitted.
Okay. Yeah. And I haven't, and this was just, I'll acknowledge my shortcoming here, but I have not, I forgot that this was reset for today. I was off last week, and so I haven't read the reply yet or the response yet. So I'll need to take a look at that and then get you all in order. We've already got a trial date set, so and it's off a fur piece, as they say. So I think I've got time to get on this. Okay.
All right. Thank you, Judge.
All
Thank
right.
you, Judge.
Thank you. Put that right over there, Crystal. Mr. Gillenwater, I'll take your case next so that you don't, because there's, I think you're probably the only person here on it.
Whatever you say, Your Honor. Patience is my middle name.
Your Honor, this is Martha Brown. I'm here today for the defendant, Barbara Coomer.
Okay, very
Hello,
good.
Martha.
This is 20 CI 566. All right.
Good morning, Judge. Ken Brown on behalf of the intervening plaintiff, James Duval.
I thought that was you, Mr. Brown. You're so far away, I couldn't tell.
Sorry about that, Judge. Hopefully you can hear me okay.
So this is the motion. Yeah, I can hear you fine. This is Mr. Gillenwater's motion to be given leave to withdraw. Is that right?
Yes, sir. I tendered an order.
Yeah, I believe that there was also kind of running parallel to this, a motion to compel that was it Ms. Brown? Were you the one that filed that?
Yes.
That because you weren't getting
True,
some
Your Honor.
discovery?
Yes, that is correct, Your Honor.
I noticed that, or I guess I have interpreted some of the things that I've seen in here that you don't necessarily disagree with the motion to withdraw, but how do you think that affects your motion to compel? I mean, we had done an order on that, hadn't we?
Your Honor, that order has been entered and the time in the order to supply the information has expired. However, as I told Mr. Gillenwater, since it's undetermined at this point as to whether he's going to be allowed to withdraw, that I would not pursue further action on that until we figure out what's happening as far as his continued representation in the case. So.
Yeah, yes, ma'am. Mr. Brown, do you consider that you have a horse in this race, or are you just here out of an abundance of caution?
Well, Judge, we're an intervening plaintiff. There were several individuals involved in this auto accident. Mr. Gillenwater had filed suit on behalf of his clients, which were several people in the collision, and we represent Mr. James Duval. So I do have a stake in this as far as, Mr. Gillenwater was one who filed suit in this, and we joined as a result of it. And his claims are going to be kind of hanging out in limbo if Mr. Gillenwater withdraws his counsel.
Okay, so do I take it that, does that constitute an objection to his motion to withdraw, or do you just want to be involved in what we do going forward as far as giving additional time and so on?
Well, I guess potentially a little bit of both, Judge. I don't think it's officially an objection to his motion. He had asked for an agreed order, and I really wasn't willing to sign an agreed order dismissing him, just because of what was stated, Judge, that our plaintiff's claims will be hanging out there if there's nobody representing all the other plaintiffs in this matter.
Yeah, I was trying to remember, this is a case that not really much has occurred as far as inside the courtroom. So I don't really know the factual underpinning of it, but it isn't something that you could pick up the ball and run with in the absence of Miss Firkin having representation. Is that what you're saying?
Yeah, I think we may have lost Mr. Gillenwater.
Well, he's still there.
Oh, is he? Oh, okay. I don't see him.
He's just being conspicuously quiet.
Okay.
Unusually quiet.
I was going to
Oh,
say,
there he is.
you must know him. And that's why you were alarmed that he wasn't saying anything.
and
I can see him, but I can't hear him.
All right. Yeah. Because what I'm trying to figure out is I'm kind of reading between the lines here, but I'm getting that that Mr. Gillenwater's not getting the kind of cooperation that he feels like he might need to adequately represent the interests of his client. And of course, if there are orders to compel out there that he would feel obligated as an officer of the court to comply with, but he can't get help, necessary help, then it puts him in somewhat of a bind. And I think we've all, maybe not all been there before, but we have all experienced that either directly or vicariously. And therefore, I do not, I'm sympathetic with what he needs. I guess I'm just trying to make sure that Mr. Brown, that your client's claim isn't, invalidated by the fact that this other person might not be actively pursuing her own self-interest. But I don't know that that's the case. I mean, if I let Mr. Gillenwater out, are you saying that it's going to make it difficult for you to proceed?
Well, we can still proceed, Judge. It's just, I believe after talking with defense counsel, our client's claim is just going to be kind of hanging out in limbo, basically, if nobody can get in touch with these clients who Mr. Gillenwater is currently representing. I don't know if moving forward, And it could be a time will tell type thing. They may get other counsel, or they may just contact defense at some point. But for the time being, that leaves my client's claims in limbo. But we still have joined as an intervening plaintiff, so I think we've protected his interests.
Yeah. Go ahead, Ms. Brown.
Yeah, and your what I was about to suggest is when we started this process, we were willing to allow 60 days for the Mr. Gillenwater's clients to obtain new counsel. At this point, about 30 days of that has expired. So I would suggest at this point, if he is allowed to withdraw, that we reduce that time to 30 days, and then perhaps if no counsel forthcoming, just deem that they were proceeding pro se. The problem is that there are 8 people being represented by Mr. Gillenwater, and there is some basic information that we are going to need from them at some point to be able to determine exactly how serious those claims are.
Yeah. Again, I'm just gonna, I guess, reiterate that I don't feel that, Mr. Gillenwater, I believe, has done this certainly in our local rules, and then I just think in the way that as a matter of course one should proceed. I mean, he's given notice and he's filed the motion, and he has expressed, I think, a good cause. I don't think that I should compel him, in a form of indentured servitude to continue doing something that he doesn't want to do when he's done everything that he should do to bring it to my attention. So I do feel like it's appropriate for me to let him out, and then, we'll just have to deal with what the sequelae of that decision turn out to be. But I don't have a problem giving a finite amount of time for these folks to acquire new counsel. I would expect, they should have probably already been thinking about that. I guess it's too much to expect that they have been, but they do have, I would assume they've got notice of all of this. I know that he's filed the motion.
Well, I can't respond to that, Your Honor, because I hadn't heard a peep out of him in forever. Try as I might.
Yeah, well, you sent a motion and it didn't, and you even have put the addresses in your order that and also in your motion, and I'm assuming that you would tell me if those came back. So I would guess that those have been delivered in, some, I guess we still have some form of a mailbox rule type of thing going on in this day and age.
I sent them to their last known addresses. But Your Honor, I'm sorry, maybe my hearing's bad this morning, but could Your Honor synopsize the basis for any objection of me withdrawing? I didn't follow opposing counsel.
I think Mr. Brown's point is that you initiated the litigation on behalf of these clients. His client intervened, and they feel like, to a certain extent, I don't know that his claim being derivative of their claims is the right way to put it, but that it's dependent largely on them pursuing their claims, and he feels uncomfortable with agreeing to allow you to get out, knowing that might leave his client kind of hanging a little bit. But I think he stopped short of giving a spirited objection to it. It was just more that he didn't like the idea. But I think that, in your situation, in the situation that you're in, I would be more ogreish than I feel like being if I didn't let you withdraw. I mean, I don't feel like doing that. So,
well, you don't look ogreish, Your Honor.
Well, I'm trying to maintain appearances, Tim. So I'm going to grant your motion. Ms. Brown had signed, like she said, she had agreed 30 days ago to give them 60 days to find replacement counsel. So I think it might be fair to call it 30 days at this stage, and then see where we are. I mean, this doesn't mean anything's getting dismissed at this stage or anything like that. And it's not even an automatic dismissal. I mean, they'll be proceeding pro se, which people are allowed to do. So we'll just have to kind of play it as it lays when we get down the road after that time period has expired. Yes, sir.
if I could make a helpful suggestion, if you let me out, why does an opposing counsel, a co-plaintiffs counsel, just call up my plaintiffs and try to get them on board, and he can be their lawyer?
Well, we'll just let that simmer. And Mr. Brown can do whatever he feels like doing in that regard.
If it was that easy to get a hold of him, then he probably would have been able to talk to me. So I have a feeling it's not that easy.
Yeah. That might be easier in the conception than in the execution. I'm going to sign this order. I'll modify it because it's got the 60 days in it, and I can go in there and change that to 30, and we'll go from there. Okay.
Thank you, Judge.
Thank you, Your Honor.
All right. Thank you.
Your Honor, that's all I had, if I may be excused.
Yes, ma'am. Thank you.
Have a good day.
That's all I've got to, Judge.
Yes, sir. Thank you.
Thank you, Judge.
Let's see. 20 CI 29, that's the Overfelt. That's all, that's the Shogun et al. Case. Believe we've got, I know we've got a bunch of, I know Mr. Wingfield has filed several motions. Those are not set for today, correct? So we're not prepared to argue those. Those are set for 2 or 3 weeks down the road, right?
Yes, sir.
So this is the motion to compel that we're here to talk about today.
Yes, sir.
All right. There's Mr. Louder. I was wondering.
Your Honor, Matthew Londrigan standing in for David Barnes on behalf of the third party defendant auto owners. I just wanted to state my appearance.
I got you.
Thank you.
Thank you.
Thank you, Your Honor.
All right. I have looked, or I've read over your motion, so I'm familiar with it. I've read over the response, so I'm familiar with that. I don't know how much you all want to talk about, or if you want to rest on what you have filed, but we've probably got a few minutes here if you want to. We don't have an abundance of time, since I've got a big docket at 10 o'clock, but I've got a few minutes if you all want to chat about it a little bit. If there's anything that you think might have been hard to put into words in the written form, and you feel like you can do it better verbally, I'm all ears.
Judge, I don't have much to add. I know you do a good job reading these things. I've reviewed the response. Our motion to compel is really just geared toward the discoverability of, the deposition questions that we ask, and the witness was improperly instructed not to answer. So, it's a pretty simple motion. We've cited the law. There's an abundance of Sixth Circuit cases that speak directly to the discoverability of the profits of a company, the economic status of a company as it relates to punitive damages claim. The punitive damages claim in this case, I know I saw a motion come through. It's not set for today, but they kind of reiterated this same argument in their response in this motion. This punitive damages claim is asserted against Shogun. It's really not this isn't it's directed to them based on our negligent training, negligent supervision claim. As we've reiterated, Shogun did virtually nothing to train these chefs that were utilizing fireballs just a few feet away from customers. So it's not a ratification. We didn't name this chef that started the fire individually in this case. That provision that they've cited really it's really not relevant. If the court finds it relevant, Shogun certainly should have anticipated the conduct. That's the requirement, under KRS 411-184, they either ratified it or anticipated. Every witness in this case has acknowledged that they recognize that it was could be dangerous and could harm customers if these fire presentations were not performed in a safe manner. So I don't think there's much argument that this wasn't something that should have been anticipated. But beyond that, Judge, if the court has any other questions or wants me to address anything that was noted in the defendant's response, I'd be happy to.
Okay. Let's let Mr. Wingfield have a crack at it, and then we'll.
Your Honor, just respond and limiting my arguments to this motion before us. Our
Sure.
position, what Mr. Louder started with, that this was about discovery of profits of a company, hits our point. Mr. Yoon's an individual. If they wanted corporate financial data of Shogun, they should have done a 3002 deposition. It's not fair. I think the premise is fair under the law to ask Mr. Yoon without warning financial information about Shogun, the restaurant, since he was called as an individual. Those type of questions and information should be discerned from Shogun directly or an attempt to via 3002 motion. That's the reason we stopped it. To ask him off the cuff without anything in front of him with no preparation to opine about Shogun's finances, a defendant as if he was speaking as Shogun, is wrong. And that's the reason we stopped the questioning. Mr. Young was noticed as an individual only. And for that reason, we think what we did was appropriate. And if the plaintiffs want that information, they can ask it of Shogun directly and ask for a 3002 deposition. But getting it from an individual, Mr. Yoon, is not proper. And that's simply our position. It's laid out very well, I think, in our response. So we would rely on that. But the emphasis to us is Mr. Yoon's an individual. He was called an individual capacity. And they were clearly seeking testimony from him to bind Shogun, a corporate defendant.
Judge, I might also add one point, if I may, Your Honor. In this situation, there is no definitive manner in which to discern the profits from the operation of the Glasgow hibachi tables. As we indicate in the memorandum, you know, Shogun of Japan is really 3 separate restaurants. We don't break profits down by hibachi, teppanyaki. We don't break it down by Glasgow, Kentucky. You know, that information is not readily available. And so what we would be providing would be a profit margin or a loss across the company-wide against several locations that don't have any connection whatsoever to this lawsuit. And that would be highly prejudicial to Shogun in this situation because it would mislead a jury to believe that, or the plaintiff could lead the jury to believe that the profitability of the conduct is directly related. And we set out a number of cases that talk about the fact that there has to be a nexus between the harm. You know, for example, if I was, you know, parasailing and using a boat and pulling a person down the ocean front with a parasail behind me and I crippled a patron in that situation, there's a direct nexus between the operation of the boat, the parachute, and the profitability of that operation. Here, that nexus does not exist. We sell Coke, soft drinks, desserts, appetizers, all these other things, and the profit all is in one pool, Your Honor. And in the profitability of the company is over several locations, not a singular location. It would be impossible. It would be extremely unfair to Shogun of Japan for that number to be paraded in front of a jury at this point. And it's extremely late in this game for the plaintiff to be asking for this type of documentation. You know, this is something that we should have done 1.5 years ago, Judge, not against the backdrop of the discovery cutoff, which was April 9th, Your Honor. So it's way late in this game to be doing this. And as Mr. Wingfield indicated, you know, we designated a corporate representative early on. I can't speak as to why the corporate representative's deposition was not taken in this case, but if that had been something that the plaintiff thought was absolutely crucial in this situation, we should have gotten a 3002 notice 1.5 years ago. And as the court knows and has seen in a 3002 notice, you laundry list almost like a subpoena ducis tecum, the various things or subject matters that you want the officer or the individual to testify upon. That's not been done in this case, Judge. None of this has been proper.
All right. Yeah, go ahead.
I'll start kind of reverse order. The last point that Mr. Judd just made, the corporate rep that Shogun identified was Ken Judd, who's also counsel of record in the case. Mr. Judd's also the one that certified the responses to the interrogatories in this case. If he's going to be a witness / attorney, we're just going to call him at trial. I guess that's how we'll handle that. But we're getting way beyond the discoverability and the essence of our motion, which was a motion to compel because they improperly instructed a witness during a deposition not to answer a question. All these things that they've said, that's not the reason that they instructed this witness not to answer, at least not what they gave on the record. They instructed him not to answer regarding any profits and said it's not discoverable. It's improper. It is discoverable. If they want to make a later motion in limine to exclude this based on these arguments they're making now, I suppose they could do that. But there is a nexus here. The reason it's discoverable is because the chefs have acknowledged that this fire presentation they do, the hibachi grilling, is what brings people to the restaurant. That's what they want in the restaurant. That's the entertainment of the restaurant. And they've, I have reason to believe, generating revenues, net revenues in the millions of dollars, and they've spent no money on training. So there is a nexus there. And they can try to, create a smoke screen and confusion with, well, you can't really, but I think what they're going to have a hard time arguing is that they spend any considerable revenue at all or profits on training. So that's the nexus there. Again, there's no basis to instruct a witness not to answer. We've now missed this. What I anticipated doing is if Mr. Yoon testified, I don't know, or I'd have to, look at my documents, or he could have said any of that. There's no requirement that we have to notice him as a 3002 corporate rep for him to give us his testimony on what the company makes. He's the 80% owner of this company. So, now we've passed the discovery deadline. If he didn't know, I was going to send out some written discovery, asking him that. Instead, he's instructed not to answer, and I have no idea what his response is. So what we're asking the court to do is compel him to provide a response, and then we can flesh that out as is necessary.
Well, here's the deal. All right, we got a short time frame here because this thing is set to come up for a trial, as all of you know, in 60 days, right? You've made a claim for punitive damages. You're entitled to discovery on the punitive damages. I don't think you can make it a defense to providing things that our company's just too complicated, to provide the information that we have to provide. I mean, if that was the case, every time Walmart got sued, when anybody asked for punitive damages, they'd say, gee, we have a ton of stores. I mean, how are we supposed to be able to tell you, how much money we make? That can't work. All right. So you're entitled to that. I don't want to get into, because we're in a big hurry here, as far as I'm concerned. And I think you're entitled to that information. I don't think that it's from what I have read in these motions and responses, I don't think it was necessarily anybody's intent to be obstinate without some kind of reason, because I do think that there's an issue about whether or not he, noticed as an individual should have been at least expected to have that information. But I think now, at this point, we know that he didn't have that, or he didn't provide any of that information to you. I think he needs to provide that information to you. And I think we need to do it fairly quickly so that we can move on. I don't know whether we're going to have punitive damages or not. I know that that's the subject of one of the motions in limine, but until that gets decided, you have a claim for punitive damages and you're entitled to discovery on that claim. All right. You pointed out, which this is the argument that we get. I mean, it's almost just routine at this point, not only in this case, but in a lot of other cases. Everybody always wants to complain that's not discoverable. That's not discoverable because it's not admissible at trial. And those don't have a whole lot to do with each other. Whether something is discoverable and whether it's ultimately going to be admissible down the road are not the same question. And so I don't know whether we're going to have a punitive damages instruction when we get to the trial. I don't know about any of that, but I know that you're entitled to discovery on the net profits of the company that you have sued and requested punitive damages for, at least from the standpoint of getting that information and evaluating it. All right. So because we are running out of time, and because I wouldn't consider that you missed your discovery deadline simply because you had this motion. I mean, you tried to get it before the deadline was up. I'm going to order that stuff is produced to you. I'm going to probably end up ordering that it gets produced a lot quicker than anybody wants to produce it. But that's because I think we need to have it at the very least before we get back on whatever day, May the 6th or whatever day that we agreed to do those motions in limine. which is essentially 3 weeks away, 3.5 weeks away. So I'm going to say that information needs to be provided by May the 3rd. All right, Monday, May the 3rd. And, I'm not going to require you because there isn't enough time to do all of these things. We've had a trial date set for a long time. We need to be ready to try it if we're going to be able to, if it needs to be tried, everybody's geared up for it. Everybody's ready to go. We need to keep that date. So we're not going to be saying, notice this guy and notice that guy and set a depot and haggle about when to have him come in just to tell you he's going to give it to you. We're not going to do all that stuff. All right. He just needs to provide it to you. Okay.
Sure.
By May the 3rd. I'm not at this point going to rule on any sort of attorney fee because I want to see how all this goes first.
Judge, if I might ask for a clarification, if it would be acceptable.
Yes.
I understand the court's ruling. We would humbly ask for some type of protective order, confidentiality agreement that it not be disseminated beyond lawyers' eyes only, if that would be acceptable with the court. I know we don't have a motion before the court, but I can.
Yeah, listen, at this point, I'm trying to just facilitate the exchange of information. So I will say that whatever information that you provide to the plaintiffs, that they need to just keep that in-house pending any other further orders, or, if we get to the point that we have a trial and it needs to be introduced, anything needs to be introduced into evidence, that's different. But I mean, I guess I don't necessarily want to say protective order because I'm not writing out something and putting a bunch of details on it because we just don't have time to do that. But I do want that information that you provide it under seal and it stays in-house with the attorneys and their, paralegals or whoever else is working on the case with them.
Yes, sir.
And not disseminated publicly. Okay.
Yes, sir.
I mean, not that I expect that you all are going to put it on Facebook or anything, but I mean, he's asking, and I think that that's fair because we're just trying to get this thing done. Okay.
Sure.
All right. Anybody got anything else right now?
Two quick points. So I
Yes.
assume the disclosure is data only, correct? Not paper, just the sheer data.
Well, I'm glad you asked that question. Judge, that's one of my concerns, what we're going to get. It might be better if I craft an interrogatory request for documents today on this to make sure we're not just getting some, 3,000 foot overview of something unaudited financial statement. I mean, I kind of want to be particular about what we're getting.
You can craft and request for production of documents, and if you can do that by the end of the day, that's what's going to have to be responded to by May the 3rd. Close
Yes,
the
sir.
All right.
Thank you, Judge.
All right. Thank you. And listen, I'm not going to, I think maybe I let Mr. Louder get out of here. I'm not going to have time to write all this up. Okay. So I'm going to make a calendar order and just say that, that the information is to be disclosed by May the 3rd. My staff attorney's back here taking copious notes. I can hear her clicking away. It sounds like a rodent farm back there. So, we're going to have everything written down, and if we need to get back into it, but I'm not going to have time to write up something big and detailed. Okay.
Yes, sir. Thank you, Judge.
Thank you.
All right, everybody. Just, I know that most of the rest of you are here on the Bush case, but I can't find it. There it is. 20 CI 561, right? So this is the bank's motion, South Central Bank's motion for okay.
Your Honor, it's my motion for judgment for South Central Bank. There's a few properties that weren't subjected to the previous order that was tendered, and I entered the case late, so I had to file a complaint late, and the time period is passed now for responses. I think everything's pretty much agreed upon, and it looks like I think Ian just tendered an agreed order
Yes,
Yeah,
Your Honor.
Kaylee just handed that to me just now. So, right here, correct?
Yes, sir. That's the one. It's gone through a number of different revisions, and Ms. Cook has ultimately decided to retain a private auctioneer to auction those properties, and that's addressed in that order.
Okay, so is there anybody that's, needs to sign this? And Mr. Davis, your signature is on here with permission. So we're good to go for me to enter this.
Now, which order are you referring to?
It's this one. Can you see that?
Mr. Davis, that's the order we discussed end of last week. We discussed the inheritance tax issue, and after having come to an agreement, you gave my office permission to add your electronic signature on that.
Yes, that I have no objection to that judgment being entered, Your Honor.
All right, so you tendered that electronically, Mr. Lose, correct?
Yes, sir.
So I can, I apologize for, I know how to say your name. I had a whole trial with you.
That's okay. As you imagine, I answer to just about anything that starts with an L sound.
I understand. But I will get on here in just a minute and sign this. And I don't know, does this take care of you, Mr. Mexic?
Well, I think the agreed order only deals with the two properties that are owned by Yvonne Cook. So there is still the other property that is with Miss Bush, or I guess the estate of Bush. And Tom did file an objection, and I don't have a problem with it per se, other than, you know, I'm just concerned about the possibility, and it's unlikely, but the possibility of a deficiency balance. I think the estate would still be responsible for that, although it's not specifically stated in his objection. I think you can kind of read into it where he states that Yvonne Cook she admits she's the sole obligor on that note, and she can say that all she wants, but I don't think it changes changes the actual notes on the bank, which has Miss Bush's and Miss Cook's signatures on it. So I would just say ask for the tendered order that I submitted to be signed, which nothing's going to be sold right now. It's our full anticipation that the order of the 20 or the sale on the 24th, and then the sale that Mr. Luce's or Ian's clients are going to do by private auction, we believe that's going to take care of everything that's owed to the bank. So my intention hopefully is going to be to release the mortgages on the other two properties or the remaining two properties that wouldn't be sold, but are subject to that new order. And sorry, I sound so, I have allergies and cold right now. So
No, that's fine. That's fine. I can understand you perfectly well. Mr. Davis, I've read your objections, and I understand what the gist of them. I guess what I'm wondering is if I signed the judgment as tendered, I mean, it sounds like I'm struggling with a way to put this into words, but maybe that there's going to be, nobody's asking for this to be referred to to anybody to sell it right now, correct?
Correct.
Yes, sir.
And that it may not ever become necessary to do that if I sign the judgment, and then just with some condition that if there's going to be a request for it to be sent along to the master commissioner for a sale, that gets noticed, and we talk about it at that time. I mean, does that cover you, or are you still objecting to this judgment being in?
The problem I have, Your Honor, is with regard to the survivorship property, Yvonne Cook is the primary obligor. The estate does have secondary liability, but this involves marshaling the assets. South Central is not seeking the sale of that survivorship property. If they get paid in full from the April 24th sale, then Yvonne Cook walks with this property and doesn't pay anything, potentially.
Well,
with regard to note 3466.
Okay.
I mean, Your Honor, if the properties sell at the April 24th sale, and and cover both loans that are, or all the loans of South Central Bank, I don't think we have any other option.
Well, I mean, I guess at the end of the day, I would understand why you as the executor of the state wouldn't be happy about that, but I'm not sure why that should preclude South Central Bank from getting a judgment on something where they, I mean, it's pretty clear that there's been default, you know, and there hadn't been payment the way that the note says. I mean, if we worry about what if anything we're going to do about it later, because we don't know which eventuality is going to present itself. But I mean, right now, I think the question is whether the bank is entitled to a judgment, and I'm not sure that there's any doubt about that. Is there?
They're entitled to a judgment, but the judgment should provide that Yvonne is the primary obligor and that her property should be marshaled before the property of the estate with regard to the payment of the judgment.
Your Honor, I think our intention is to, and I think that's reflected in the order we tendered, the agreed order. There are two properties, two survivorship properties to Ms. Cook, and they are covered by two mortgages. And I think our intention is to have a private auction of those properties, which the proceeds from that auction will satisfy the two notes relative, or the two mortgages and notes relative to those properties. And then any remainder will revert to Ms. Cook, and that will allow satisfaction of those two notes. And then the other properties and equipment that South Central Bank has a lien or interest in will be sold to satisfy any outstanding additional notes or debts held by South Central Bank.
Yeah, I guess.
I think I see kind of what's the, if we can, Tom, would if we get a commitment that, excuse me, sorry. I think what Tom is concerned about is that after the auction of the 24th, that Ms. Cook might decide, oh, well, I'm not selling it, and she walks away. If there's a commitment that Ms. Cook will continue with the sale, Tom, would that alleviate your concerns?
Well, what I would hope for is that the sale will be secured on the 24th, but that the bank will forego acting on the judgment and the sale proceeds until after Ms. Cook has her auction. And applies those.
So that's kind of what I'm saying. Ian, I mean, do you intend, or do you think your client would intend backing out if for some reason, the April 24th auction satisfies everything, or enough is brought in? Do you anticipate that happening?
I don't think so. She's already been in contact with an auctioneer. I mean, the auctioneer's itching to go as soon as we get this order entered. And frankly, I think the order we tendered
will be entered first.
Yeah, I think the order will be entered, and I think the order, I'd have to look at the language. I think it requires the private auction, and then it requires the proceeds from those auctions to first satisfy the two notes relative to those properties, because Ms. Cook is a personal guarantor on those notes, I believe. So
yes,
I think those two properties will satisfy those two notes, and I think the order requires that we tender.
I think so. So I basically, if judge signs both judgments, the agreed order and the judgment, that should settle everything, especially if your client is going to continue on with the private auction.
Yeah, I guess, I mean, I'm trying to just protect, Mr. Davis's interest, and I understand as the executor, I understand what that is. And I mean, I guess it's all well and good for everybody to say, this is what we intend and this is what we think is going to happen. And I think he's wanting to basically just preserve the ability to you know, to have the property that's the subject of your judgment, the tendered judgment, not the agreed judgment.
Sure, sure.
You know, have the ability to bring that in and apply and sell it and apply it to the debt if there's any debt left over. Right? If either this property doesn't bring it, Mr. Los, if his client doesn't follow through with her sale, or if the property for some reason comes up short, which again, we don't expect either one of those things to happen. And I mean, I guess knowing Mr. Davis, you don't disagree with what these guys are saying. You're just trying to make sure that you don't get left holding the bag if these things that nobody expects to happen actually happen.
That's correct. That's
Yeah.
correct. And you see, it has to do with the sequential order in which the property sells. The sale coming up is April 24th. The proposed private sale is going to be at some point after that. And for example, if it sells, but it's continued out 120 days, for example, then the money from the 424 sale may already be distributed. South Central Bank may already be paid in full, and they have no further interest in it. They're smiling and happy. And in fact, the debt of Yvonne Cook was paid for by the estate when the estate is jointly and severally liable, but should be secondarily liable with regard to that 3466 note.
I would agree with, as long as the estate is still jointly and severally, we'd agree to secondary liability. I just wanted to make sure that there wasn't going to be like an objection later on down the road if there was some sort of deficiency balance that we tried to collect from the estate, which
Okay.
I don't think will happen, but
I don't have any objection to that. with
okay.
regard to
I think we're all in
secondary
agreement then,
liability.
Judge.
All right. So I can enter this tendered judgment, which I'll enter the agreed one first, because that's something that I can jump on here and do real quick, I think, before my 10 o'clock docket starts. I can just pull it up and do it. And then I'll go in later on and enter the other one, just so that it's clear, because there'll be a timestamp on them, which one got entered first.
That's great.
Okay?
Thank you, Judge.
All right.
Thank you guys. Appreciate it. Thank you, Judge.
Thank you,
You
Judge.
bet. This one I'll sign, 20 CI 464 Campbell et al. Versus STMCA. That's an order that it is e-filed, so I'll sign it. Discover Bank versus McGuire.
Good morning, Your Honor. That's one of mine. I believe that's on your 9 o'clock docket. And this is Jason Mosbar, I represent the plaintiff on that. That's our motion.
Okay. That's a motion for default judgment?
That's correct. We show personal service that's been perfected.
Yeah, there was a service back in January.
Correct.
Nothing has been filed. So that one looks like it's probably okay to sign. Do you have the Capital One Bank? Do you have that one too?
Whitney Wood.
Correct.
Yes, sir. That's mine as well.
All right. That is the same deal. There is, I saw that there, yeah, service back in January, and nothing's been filed in that one either.
Yes, sir. We tendered an order on both of those.
Yes, sir. I've got those in my e-filing, so whenever I get a chance, I'll get on there and sign them, okay?
Perfect. Thank you. That's all I have. I've got another court at 10 o'clock.
All right. Thank you very much.
Okay.
All right, Crystal, here.